That's idea number 13, my lord. But this matter last came up on 14th of November, my lord. And this matter was adjournment in someone or Lordship, 2 weeks. 2 weeks. It may come up after 2 weeks, my lord, preferably after 11th of December, my lord.
So you are seeking adjournment again? On earlier location, who sought for adjournment? When it was fixed? Oh. 12th. The request made by the council for the petition and with the consent of the students of Corridor. So date is fixed on 13th of December.
13th,
Yes.
madam.
It will come in.
Mention, I think on the 7th, motion column, Your Lordship. We crave leave, Your Lordship, to amend the cost item as per the latest provision bench's order. The matter was filed under the provisions of CRPC. We crave leave to amend the cost item, Your Lordship. The matter may come up on Friday with the Liberty.
No, you have already amended.
No.
Amended cost title is not yet
No, Your
furnished.
Lordship. We have to amend it, and the matter is slightly urgent also. Doctor and associated delegates. The matter can be taken up on Friday with the liberty granted to us to correct the cost item in the meantime.
Friday, Parivan. Two both matters are sent. Friday, there are many matters that we fixed earlier. In fact, last 2-3 days. Maybe on Monday. Monday can be. On Monday, Monday no. Monday may not be possible. Monday also that will be fixed. Huh? Monday also lots of matters have been fixed, in fact. Maybe Tuesday or Wednesday. Tuesday are also fixed, I think. Wednesday. Take it on Wednesday. Otherwise, these are okay. At least Wednesday, and the request for you. $43. Right? Your senior counsel is not here. Oh, Mr. A.M. Barak. Ground to likhi dibo. So after 3 weeks, list up. Interim was there. List after 3 weeks. Interim will continue till next date of listing. Friday. One amicus is also. It's a matter of 2017, in fact. $25th and Friday, even in Tuesday also, matters are already been fixed. Let it be after 1 week then. It may be after 1 week. Date cannot be. Now these 4 or 5 dates are already actually full. Maybe in the first week of December, or because these 3-4 days are almost full. First week of December, any date? 5th of December. Make a mention before the senior bench in court number 21. $40. Mr. B.M. Chaudhary will not be available. So you are for the respondent. You are for the respondent or the petitioner? Respondent. Yes, 40. With the consent of the. But the amicus is also here. Mr. R.D. Mojum, MS R.D. Mojumdar is amicus. No? The update with the consent of the appellant side. Correct adjournment. Now see, this is of 2010 matters, in fact. So we are giving only 1 week. List after 1 week. '24, '22. It should be listed on motion. Huh? It's a 24 matter, date cannot be fixed. 82,000. You are Mr. Heard Mr. R. Karim, the counsel for the petition, and it is submitted that the matter is wrongly listed in admission column. It ought to have been listed in motion column. Let the matter be accordingly listed in motion column after 1 week. We are listing it after 1 week. We cannot give you a date now. After 1 week. '47. Who is appearing? B. Datta. On behalf of Senior Counsel, Mr. B. Datta. 10th of December. Can it be? 10th is not. On 12th. Tenth is a month, Tuesday. Okay, he is outside counsel. Okay, 10, 12. Yes. One four. Here also BM Chaudhary is engaged. Item number 14. BM Chaudhary absent as na? Same ground. Counsel, engaged counsel, Mr. BM Chaudhary is not in position to appear before the court. Interim was there. Interim be continued till its date of listing, list after 2 weeks. Okay. T9. Passover for the day. You are for petitioner. Have you informed the other side? Huh? No. Have you informed the other side? No. Praying for adjournment, and the petitioner, counsel for the petitioner, they were also asked to inform the engaged counsel for the respondent accordingly. However, considering the submission made by so and so, it adjourned credible and list after 2 weeks. Okay. '41. He was amicus for the appellant. Huh? Huh? Ah, yes, I know. Very consent credible. Mr. Vidala said, paying for adjournment, stating that Mr. K.P. Pathak, the amicus curiae, is not in a position to appear before the court today due to his personal. This is also 2017 matters. After not BS, after 2 weeks. After 2 weeks. '21. Make a mention before court number 21. 25 is in order column. Today only. So here, names of 3 councils have been reflected for respondent number 1. Now, state is not here. State is already there. State is 2. Oh, achha. Appeal 25 to Kobo. With the consent of the other side, Mr. S.M. Abdullah, the counsel for the appellant, read for the adjournment. Further, it is submitted by Mr. P. Chaudhary, the learned and counsel for the respondent number 1, submitted that he has appeared on behalf of the respondent number 1 and prayed for the furnishing the copy of the Matrimonial memo. Full stop. Appellant is accordingly directed to furnish the copy of the appeal memo during the course of the day. List the matter accordingly. So it should be in now admission column. Appeal is already admitted. Can be heard, that means. No, date may be fixed for hearing column. At a date of any date can be. At the month of December only now, so it's not possible. 12th of December. 14, 15 is a holiday. 16, 17. 17 can be otherwise. 17. 17, 12. Is the matter in the hearing column, huh? Okay. Criminal petition. Please make mention in a scene before senior bench, court number 21. Court number 21.
Release for motion item 1.
Yes.
Then only 2 days were fixed. After 1811, find my evidence number that says 27. This is 600 I find on 1811. Then the ownership reflects. Case number. Case 42. Case 42. 1811. And then it was again fixed on 91. And then we find these 91. Then another date we put together for cross
Your this thing is not, order sheet is not completed as 16, 12, then again 6, 3, then again it is half written.
91. After 16, 91. After 91, the next date is 42. This 46. So only 2 days 6-3, unfortunately, the DW3, the independent witness, who was a lady, was absent due to some urgent reasons, personal reasons, and he states. But what the London trial of my entire education of 6 months, minus to find that order that is 48, 47, that is the time. See, this is about very short, but I'm not to this training. Seeing the medical prescription, also has absence of right procedures from the grounds for practice not restricted. Hence, we have to follow my rejected and evidence of details of saying yes, 6 months. So, this is my case. And we could see the independent perhaps because any condition was lost in the because it was asked this one that what we could see the evidence I paid before the running system, but they were also that's why I'm here. So next day, this 6 for 16-12 for cross of DW2. DW2 is process yet to happen. So now, this petition will dispose of any all the
Okay, issue notice corridor. Stay corridor. Notice. Against you, this is in you have filed this petition. When you have filed this petition? Then again under CRPC. No, that is different thing. But you have filed this one and again under CRPC. Now, there are some thing that if suppose IPC section case is registered, then IPC will prevail. And if it is filed, this is a fresh petition filed by you or criminal revision petition. Just change the cost title. Handwritten. No, handwritten is not permitted. Just amend. Will it be possible you for tomorrow? Maybe on otherwise day after tomorrow. Tomorrow? This day matter tomorrow, and the petitioner side is hereby directed to amend the case cost title of the petition as the petition has been filed under section 397.401 of read with section 482 of CRPC. List tomorrow. Okay, we're listing it tomorrow.
Item 2.
Tomorrow is 20. No?
Not against the respondent. So many allegations against the but nothing says YCFT and matrimonial against the income of
So it case has already been awarded. I mean, the maintenance has already been granted. What is the quantum? Quantum of maintenance?
1,030,000.
30,
30,000.
1 3.
Income of the petitioner is only 30,000. If there is anything in title, respondent is herself said that she is an ethical wife and she adds something for her material purpose.
Okay, at present we are issuing notice because it is a matrimonial affairs. We do not want to pass any order on stay here. Uh, by issuing notice to the respondent. This address is proper, na? Issue notice করে দিব to registered AD and as usual process. Also call for the scan copy of the LCM. Please the matter accordingly. The order was passed on 4/10/2024. We're listing it after 4 weeks. Take steps within 2-3 days, and we are also calling for the LCM.
Item 3,
Yes. Three? Kidnapping. Acha.
She allocated petitioner for only because it is all being exercised by the petitioner. That is the case here.
Have you filed any other IA? No. Page? And your petitioner is in previous bill. Your previous bill. Okay then. And regarding the prayer of stay and all, you have. Anyway, have you annexed the order that he is still in previous bill? Is there any order? Otherwise, it seems that he is in previous bill. Heard Mr. M.A. Islam, the counsel for the appellate, petition, and also heard Mr. R.J. Purva, the learned additional PP, appearing on behalf of state respondent. This is an so-and-so corridor. Application under section 442 oblique 438 of the BNSS against the interim judgment and order dated 11/9/2024 passed by the learned session judge Kamrup Amingaon in session case number 64 of 2021, convicting the present petitioner under section 363 IPC and sentenced him for RI for 2 years and to pay fine of rupees 10,000 in default, SI for 1 month. Full stop. Appeal is admitted. Issue notice to the respondent number 2. No formal notice. So and so. Call for the LCM. Mr. Islam further submitted that during the entire course of the trial, the accused was in previous bill, and after conviction, the accused is still was in bail, and after the conviction also he is still under a previous bill, and accordingly paid for suspending the sentence passed by the learned session judge dated 11/9/2024 till disposal of the present petition, and also pray to allow the accused petitioner to remain on previous bail till the disposal of so. Next prayer allowed. The बाकी suspend করে দিব, let him be in previous bail. ঠিক আছে? Till disposal so and so. This is the matter accordingly after 4 weeks. Take steps on respondent number 2. We are calling for the LCR, admitting the revision, and we are.
Four.
Yes. Item number yesterday's item number 10. $19. $14.5. And how many other cases is this accused your petitioner is having? This is the second, and 7 numbers of cases. In both the matters, it is POXO. Yes, Burwa, yesterday one order was passed. In fact, considering that one. Hmm. Oh, that I don't, that we don't know. Huh? Last date of order is 6/11. Now next date is no, it's true, but the question is that he was present 2-3 occasions with the DWs because of the absence of the council. I mean, sorry, the court, and that could not be taken up. And that thereafter, most probably 2 dates were there. No, no. Huh? On 14/5, 2 DWs were there. Then on 11/6, 1 DW was present. Yes, obviously, thereafter on 22/07, they were absent. And 2 consecutive dates. That means on 28/8/2024 also remain absent. So considering this aspect, actually yesterday's matter was allowed. Most probably the accused being the same person, the matters were fixed together, I think. It was. May not be connected, but it was fixed together before the learned special judge. Accordingly, that's why the dates are also same. We'll record your objection definitely. ইয়াতে যেটা আছে ইয়াৰ পৰা মিলাই লিখি দিব পাৰিব more or less same order. Now here on the other hand যে আছে ইয়াতে Mr. Borwa's submission to দিব. Here one more line you add. He further submitted that in page number 3, I have marked it. He further submitted that as the matter is as matter is relates to POXO, the respondent slash respond number 2 respond number 2 slash the informant should be heard before passing any order. It will like to look at it. Otherwise, dates are also almost same. I will check it and then try to pass it. Dispose of at the stage of at the motion stage itself. Okay, it is also disposed of. Yet at a ভিতৰত আছে এইটো দেখাৰ দি দিব.
Item 5.
This is the matter is this.
sitting principal got retired. She in the eldest one. She got the post of in charge principal and regular selection. The respondent number 2, who is the informant of this case, challenged a particular order before this court by referring. Now, when this she took as a principal, Saraswati Puja and certain things were there. There's some cash went her with regard to that. And all of a sudden she had a health problem. And as a she could leave and take to Guwahati for her treatment. And leave was sanctioned. Now in the meantime, that regular selection process that was held, results came out. And the person who have preferred the petition Mala, he got selected. Then this petitioner challenged the particular order. This Honorable High Court put both the matters together, dismissed the matter, both the case together. Now, after returning my lord, and the principal responsible took intellectual charge of that particular principal post when she was on leave. Now, on her return, whatever money and cash was there, she offered it to the principal. He refused to take. If it's offered to the accountant, he refused to take. She went to the inspector of schools, who is the appointing officer. This inspector of schools directed her to present it in the case of in the way of a draft. She presented to the principal, she refused to take. It's been given to the accountant, he refused to take on the instruction of the principal. Now, principal was in it, on the basis of which during investigation she was not arrested, but she was charged-sheeted in that case. No sanction was there. Now, one PW was examined, and during the examination of that particular PW is the informant himself, and he said, I am not taking answer. Now, at the immediate stage, she was never been advised that you can go for cautioning or otherwise revision, because sanction is not there. But lately she got this, and so a revision application was prepared to delay confirmation petition. So, for delay confirmation petition, notice was issued to the informant. Informant objected to it. But the learned court totaled the delay and admitted and stayed the proceedings. Against the particular order with regard to delay confirmation, the principal came here before this honorable court, where this honorable court has dealt with that matter. And ultimately, the trial court order was upheld, and that petition with regard to delay confirmation was dismissed. That was preferred to the principal. Now, 2023, the matter was hard after the dismissal of this case. 2024, lately nothing was done. The petitioner side completed the argument, day after day after day. Being accused, because she ultimately retired from service. She is getting provisional pension and not the regular pension because of the pendency of proceedings. So she preferred a quashing petition before this honorable court, seeking a time frame so that for the disposal of the case. But this order was communicated to the lower court, not as it is. And later was disposed of, stating that, my lord, I take your lordship to the impute order, what I actually do. That, my lord, will come to them. That's cast for my lord. Page 76. 77, my lord, FIR contents have been mentioned, my lord. I'm not on that. Also, what is the finding? That is a page 81. The learned speakers cannot consider this finding. Written arguments were submitted. Constitutional benches, judgment were cited by law, not been deactivated. And one liner that this case is not appropriate, applicable to the present facts. I come to the present facts. But here in the Islamic case, we see there is a dispute between the religion and the opposite party. It is admitted fact that the religion prior to going to federal legislature hand over the money belonging to the school, which was in her custody as per rule before the appropriate authority. Though she had ample opportunity to do so, and thus I find the clear misappropriation of school public money. Please finding the religion cannot come in, deciding that. Secondly, my lord will tell us, as per financial rules, a public servant ought to deposit the school so and so in the school account or remit into the treasury on the same on the next day morning. But here it is saying the religion had to appropriate depositing the school money prior to going on leave on medical grounds, but she did not do so, thereby violating the financial rules which is available to all government servants. Hence, after returning from her leave and trying to hand over the unaccounted money to the responsible government, which was entrusted to her, on her assuming charge, which clearly shows that keeping all the official money with her, which ought to have been deposited in the account of the school cannot be held, that she had to keep the money in charge of official duties. It is several laws that already discussed about that a public servant cannot keep public money in custody and have deposited so. Therefore, I find the plea taken by the revisions that the learned Yoato has evaded law by taking public against without consideration votes for value. I do not find that the unaccounted money kept in custody of the region cannot be held to be kept in charge of officers. So, sanction is not required. My lord, may I take your lordship to the written argument that starts from page 52, and I straightway, my lord, enough facts have been discussed here, and I straightway come to, my lord, the constitutional bench judgment, which is on page 57. In the 5 judges judgment, and that's Golden Field as on today. Question is that whether prima facie offence is made out or not. The section comes in doing the reasonable condition between the official duty and the act complained of. That is the safeguards. Where the Supreme Court, my lord, the petition stating in the argument that is relying on the judgment of 5 judges of the Supreme Court, where the Supreme Court held that if there is a reasonable connection between official duty complained of and the act or omission on the part of the public servant, that sanction is mandatory. Without sanction, no trial is initiated. The facts of this case, the allegation in the aforesaid case was that Mr. Darwan's voice of an alleged authorized American state premises security so he found that the income tax official proceeded break open the entrance of the requisite flat and went inside and interfered with some officers and drawers. It is further alleged that the income tax official tied him with a rope and assaulted him, causing injury. On this fact, a complaint was filed so. That in the aforesaid case, learned magistrate with cognizance and issue processing in practice also. The petitioner states that the aforesaid case was challenged before Honorable High Court, and Honorable High Court caused the aforesaid case on the grounds that the nature of allegation against the petitioner was something in the act, as against in which attaches to the official character of the petition, and as such, without a valid sanction, the case cannot be proceeded and sin was quashed. Then the petitioner stated that the state went to the Supreme Court. Supreme Court, it is laid down before the 5 judges of the Supreme Court in a constitutional rights. The Honorable Supreme Court applied the case with regard to the language incorporated in section 197 of the CRPC, which states that any offence alleged to have been committed by him while acting or purporting to act in official discharge of his official duty. The Honorable Supreme Court further observed that the offence alleged to have been committed must have something to do or must be related in some manner in discharge of official duty. The Honorable Supreme Court further observed that no question of sanction arises under section 197 CFC unless the act complained of is an offence. The only point to determine whether it is committed in discharge of official duty. There must be a reasonable connection with the act and the official duty. It does not matter even the act exceeded what is strictly necessary for the discharge of the duty, as this question will arise only at the request where the trial procedure is valid. As a petitioner states, the Supreme Court observed that in a given case, considering the allegation, court must find out whether the act and the official duty are so interrelated that one can postulate reasonably that it was done by the actual performance of official duty. Though considering in excess of the need of requirement of the situation, the petitioner says Supreme Court in paragraph 19 of the same judgment clearly came to a finding that when there is a reasonable connection between the act and the discharge of official duty, the acts must just some simulation of the duty that the accused should be reasonable, but not a pretended fanciful claim. In the aforesaid case, the Honorable Supreme Court applied the judgment of the High Court. Now, another judgment by 3 judges, paragraph 26, we can see the facts of this case. In paragraph 4 of the so next page, the allegation. The allegation level against the appellant of the aforesaid case is that he being the chief accountant clerk, superintendent assistant cashier of Madhya Pradesh Electric Supply Enterprise run by the government of Madhya Pradesh, and he is a public servant not removable from office without sanction in the government. That the petitioner states that the aforesaid case the allegation that was leveled against the public was under 409, same one. Of IDC, it is argued on behalf of the prosecution that in case of misappropriation of money, no sanction under 197 is required. That was an argument that was. The petitioner states that in the process, the Honorable Supreme Court had come to a finding that whether an offence was committed in the course of prosecution will depend on the facts of his case. The Honorable Supreme Court stated that case to be applied to determine whether or not an act is one purported to be done in execution of duty as a public servant. Honorable Supreme Court came to a finding that a question of substantially one of fact to determine the offence with act complained of and the attendant circumstances. That in the opposite case, the accused is charged with misappropriation of government property by selling them with intent to pocket the sale proceeds sold the copy. The opposite fact of the Honorable Supreme Court held that as the act complained of is in connection with his official duty and as such without sanction the conviction and sentence of the accused is valid law and was struck down by of convictions. Now, all Supreme Court judgment now never be discussed with regard to conviction powers. Law is very clear with regard to this. Here is a lady in India who has been fighting for her right. These are the courts. Offer help now. She obtained the sanctions, leave and went out. Money was with her. Never been misopinions. Taken to do it. Because Assam Finance Service conducted service. Why not? The learned judge in the revision of fraud file. I'm reading it, my lord. I am reading it. It provides for financial rules power. There is nothing. Here it is being provided in this rule, unless the context otherwise requires. The government means government of Assam. The government servant means any person appointed by government to any civil service or post in connection with the affairs of the state. My lord, a government servant whose services are placed at the disposal of company so and so, my lord. My lord, under this act itself, my lord, it's been provided out here itself, my lord, that any person, government servant, before prosecution, leave of the government is necessary. There is no leave with regard to the sanction is not there. So, in that factual matrix, my lord, I would claim that a retired person will harassing this man and no fruitful result in this particular case. At this stage, I will bring my lord office filer and stay of the prosecution. This honorable court decides on merit on this matter. Hearing both the sides. And the Supreme Court law is there, there is a law with regard to this.
So now what prevented her to, furnishing all the financial things before leaving?
There was no authority. She was officially principal. There was no authority to whom she will hand over. In the meantime, she had that medical minor problem. And she took the leave of the inspector of schools and went out. Sanction leave. In between, the principal was, the regular selection was in Reserve of India. And unilaterally, that regular
He took charge, that is understood. But
on her return, she returned. Minor 2 days. And he has refused to take it. For that purpose, I can show from his deposition and the cross-examination. He had been. In that case, my lord, only say, my lord, there is a line of the Supreme Court judgment. Offence cannot be part and parcel of official duty. There is a line of the Supreme Court. But the Constitution, where the final line is this, that if a prima facie case is also been made out, then only the sanction comes in. Only this has to see the reasonable connection of official duty. Here, she took the money as official duty in connection with her official duty. Because of the health ground, that has been matter of my records and been submitted to the authorities. Even in 161 statement, my lord, it has been stated, my lord, the cashier, that she came in and returned, but the principal said, no, don't take it. So it's a personal fight being taken to that extent.
Okay. Yes.
Let's take a look. 218.
Yes.
Where is the person who is or was a judge or district? Not remove say by working the sentence. If accused of an offense, just to have been by him, by the active or purporting to act under the discussion of the no court shall take evidence of such offense, except with the bigger section 7 otherwise provided in the follow guideline. Now, Mr. Vice Speaker, also for active
1-8. Hmm.
During my holiday, this is the method of very important. During my joining at the school, she was not female of each, she was absent and it was handed over her to the mother. Accordingly, the Deputy Commissioner Collingwood by order number so dated so and so, requisite circle officer Collingwood State Public. The presence of circle officer C of assembly C of this other stuff, I took the individual stuff. Before my joining, the principal inserts and then over search to check 67. It is not earlier of the principal by maintaining all combinations for goods and among the business.
Yes, 6 lakhs.
6 lakhs, 55,000 about school fund collection, and that is very important one, the school fund collection, only table one. And this is the amount of rupees 40,770 no auditable of school fund, and student is and use of Almira and other are still in her custody. The same amount is not found in the Almira. This is very important. The same amount is not found in the Almira of the school. Same scooter that sold as retail profit in the same amount, which is the property of the school. I shall when some school staff heartily request the corporate to the post amount as well as the fees for property maintain our income. But she denied to return back the same amount as well as the fees. Now, my lord, there is my largest friend, my lord, satisfied this course, my lord. Whether these second things are in resolve for officially.
Yes, I agree.
If it is yes, I have no case. If it is no, there's guarantee that we
Yes.
take case, my lord.
Yes, my lord, I certify this one.
How it can be, my lord, in resolve for official duty?
Absolutely. I certify this. My lord, page 25D. Any country. The deposition of the informant itself will also as well. Same Ashish Das, my lord. And the informant and the accused used to work as assistant teacher at so and so so and so. On 10/5, I joined the present profile of mine as principal. Prior to my joining, the accused was in charge principal of the school. That is my lord applicant funds. On 3/5, under the order of the director of second, I proceeded to join the principal's funds school after completing mandatory officer at the office of the inspector of schools. However, reaching the place of my new joining, I thought that accused was not present. She did not hand over the charge to me. She was my lord under mediation of the deal. As the accused was not present, I met the deputy commissioner of schools. So on 10/5, I joined the present profile of mine as principal of Karimgaj Public Higher Secondary School. During the unilateral charge and over the school inspector taking writing a detail of the audited amount of rupees 6852, not 6 lakhs, 6852, and that's for Saraswati Puja. Audited amount. And unaudited amount of 23,774 lying cash in hand with the accused in charge principal. After a couple of days of my joining, the accused came to the accused and resumed her service. I requested the accused to hand over the cash amount. However, on hearing my request, the accused threatened me and she will file a criminal case against me and warned me that she would overthrow my position. Later, as per the instruction from the school inspector, I filed the SIR in relation to unaccounted money lying with the accused. Later, police visited the school, searched documents and recorded my statement. Police later gave Jima of the 6 articles to me. He did the accusation of returned the money. After the interview, the accused sent a personal check to so as the amount did not tally the unaccounted amount, the receipt check was not received by me. The accused in the meantime lodged a criminal case against me. This is the allegation of props. Before joining the Karimganj Higher Secondary School, I served in charge principal at Anumara Higher Secondary School. This is another school. I am not in this. The recruitment is made after the procedure of interview by school committee and finally board of secondary education. Apart from myself, several other teachers also appeared in the interview for the selection for the post of principal of Karimganj Public Higher Secondary School. The order of my appointment as principal so was issued on 2/5/2017. On 10/5/2000, I took over the charge. While taking such, the accused was absent at the place of my post. Later, I came to know that the accused was on earned leave under medical grounds. I was on leave. For a period of 2.5 months, the accused was in charge principal at public higher secondary school prior to my joining. I did not inform the accused in writing to hand over the charge with cash books after her joining. I did not initiate or propose any disciplinary action against the accused as it was not within my competence. However, I verbally informed the higher authority to take disciplinary action against the accused. The accused filed a petition before Honorable High Court in which I was on the response subsequent reputation of this case. The accused tendered the check so but the same was good to the inspector of schools. So I have no options. Inspector of schools I tendered. Just rotate to him. He refused. But the same inspector of school. But after consultation with the inspector of school, I did not receive the check, as the check was issued from the personal account of the accused. Later, a bank draft bearing so was routed to me through the inspector of school, and thereafter again via secondary school by the accused. But I did not accept the same and returned the same to inspector of schools. While filing the SIR against the accused, I did not receive any written permission from higher authority. Now, this is the sum and substance. Now, my lord, with regard to the sanction, what my learned friend is absolutely right. Old law, my lord, with regard to Lokpal, that is not there. Now, the new law, the change has been there. It to say, but no FIR can be lodged against a public servant with the prior permission of the Lokpal. That has been introduced. And the constitutional bench absolutely states, my lord, I may have offense, but whether there is reasonable connection with regard to the official duty. I received that money as an insult principle. I got to medical leave. And these are reasons which justifies, my lord, that I have not handed over to any other person, and this was with me, admitted facts. But whether there is nexus with my official duty, that has to be seen. And from here, admitted facts, that my lord, without the sanction of the prior authority, my lord, whatever I have done and kept the money for some time, taking during the medical leave, my lord, that money was not with my lord, it was with me. But I tendered it. Thereafter, FIR has been lost. My lord, you can see the date of FIR. It's after that, where I have tendered and thereafter, my lord, the FIR comes in. It's nothing but a 4/7/2017. 36 draft has been given to a higher secondary. He doesn't accept it. So it's a personal fight that has gone to damage. I will pray for that.
What is the stage of the case at present?
My lord, it's been stayed, my lord, as because after dismissal, my lord, she is yet to receive the summons. So what I am on at this stage, my lord, will kindly protect me with the next day so that they appear as the records are before the law.
in the evidence also, my lord, evidence also it is specifically mentioned, my lord. That as per the instruction, my lord, this is the evidence of the PW1, the information. That as per the instruction, the school inspector itemized whether in relation to the unrecorded money lying in the account. That is not believe that the school is document and recorded by document. Police letter also with Lima, obviously that is to be. In that the accused not return the money. However, in the interim, the accused said that personal say to the inspector of school as the amount did not genuine the unaccounted amount, the state is not completed by him. That has come in evidence. Yes, now my lord, where is my lord, where is your evidence? The entire act has last by the accused, my lord. This is petition, my lord. It discerned over official issue. But whether the school authorized to give the money in a personal almira, my lord. School almira.
I have kept school dialogue in my argument.
Regarding this time, madam, really appeared to the police party number 5. After appearing, madam, they go to take over the hands after getting
No, but how is submitting that the case has already been stayed in a sense?
This was stayed by the London Session Judge.
Earlier?
Yes. And thereafter, my lord, matter was hard. My lord, can you take your lordship, my lord, this honor? At least 50, my lord. Because hard, my lord, in 2022, so far petitioner is concerned. Page 50, my lord. And page 51, my lord, we came in because it was pending for more than 1 year, my lord. And that's why, my lord, within 60 days, it has to be disposed of. And by this impugn order, it can be disposed of, my lord. Wherein, on the prima facie, on the face of the order, my lord, there is no discussion with regard to the Supreme Court constitutional judgment, my lord. With regard to that she has been collecting the money on the basis of insurance principle. And that's the reasonable connection. She kept the money in the school almira and went for leave, my lord. Medical leave. This has been reflected, my lord's order.
But in school almira, there was no money.
My lord,
Money was not there in the school almira. Okay, then we issuing notice at this stage.
My lord, at this stage, my lord, at this status quo order will be required, my lord. Otherwise, if it's been summoned, my lord, harassment, my lord. She has been staying with her husband, my lord, in Kolkata now. And children are there in Germany, my lord. She's not a criminal, my lord. And the Supreme Court law has been made it final, my lord, under the judgment of this honorable court. No.
Trial has been proceeded?
No. Trial, sir, my lord, this cannot be stated as such. When a case is being stayed out here, and finally, my lord, dismiss the case. The record goes to the trial court, my lord. Then again, someone has to be issued. I, on oath, my lord, before this honorable court making a statement, we have published the summons.
No, but the case is still at the stage of evidence.
Yes, it is a case of evidence. PW1 has been examined. And that, my lord, can you see another judgment I am giving you before this honorable court, 18/7/2023, and before a police officer, my lord. And what were the allegations, my lord, can you see? Prima facie case is made out. But sanction was not there, and so it was quashed. That is the law with regard to this. And every public servant, my lord, 197 objective has been, my lord, cleared in the 1986 judgment, my lord, 5 judges judgment. Let him answer to that, my lord. Instead of objecting, my lord, and in a case, my lord, let it be, my lord, till the status quo, my lord, till the status quo. My lord, what I have
and secondly, my lord, if you decide it cannot be required. I can file my lord registered petition as per the PNS of my lord.
That's not the question. What I thought. Whether, my lord, on the facts of the case,
It's a case of my lord 2017, man.
maybe.
7 years ago, the my lord passed it, my lord, differently passed, my lord. Then the opposite party has not taken it. It is the important reason necessary. After getting my lord is available in the record. So my lord, he has to prioritize this time before the total put.
Yes.
Years of my lord, procedural section. Because the act has been done in disorder public.
Yes.
And from the extra itself, my lord, it has not been done in disorder public.
My lord, when
Okay,
I
then
want-
we are issuing notice at present. And
My lord, some kind of corrections, my lord. Otherwise,
scan copy.
my lord, when I want, there's no criminal case should be used as a lever for personal use. And when prosecution bench says, when my lord, three doesn't judgment, my lord, when in the accountant, not only Mr. Rupe during his official, he sold it off. He didn't tell the Supreme Court says this as a judgment, my lord. Says the protection is necessary. Because while officiating as the chief accountant, he is dealing in his official capacity. I took this money in my hand, in my official capacity. I retain it for some purpose because of my health grounds, which is beyond my control. And thereafter, my lord, when it's been before lodging of the affair, I was returning. It has come on evidence on record. He returned, he refused to take. Sir?
Because it was not matched, my lord.
No. This- Yes, yes. Yes.
Yes, but suppose it was not matched. In that case, he could have informed her that it's not matching. So why don't you file a fresh? I mean, and the amount is not 6 lakhs. I think it was 6,685.
Absolutely.
I don't know the proper correct one. The one once it is written as 6 lakhs something, and then again it is seen that it is 6,000 something.
6,000. And in
Maybe whatever may be the amount.
even 1 rupee. That can
Okay, then heard Mr. A.K. Bhuyan, the counsel for the petition, and also heard Mr. R.J. Burga, the learned additional PP appearing on behalf of state respondent. This is an application under Section 528 of the BNSS, read with Section 482 of CRPC for setting aside the order dated 27/9/2024, passed in criminal division petition number 40 of 2021 by the learned session judge Karimganj. Issue notice to the respondent number 2. No formal notice is required to be served on state respondent number 1. However, as additional PP has already appeared, however, extra requisite copy of the petition may be served during the course of the day. Next paragraph. Also considering the submission, it is also further submitted by the learned counsel for the petition, Mr. Bhuyan, that till the disposal of the present petition, the further proceeding in GR case number 1448 of 2017 may be stayed. May be stayed as there is sufficient material to show that what is that the money which was alleged to have been kept by the petitioner was in connection with discharging her official duty, which she was received while she was working as a in-charge principal of the school. On the other hand, Mr. Burwa, the learned additional PP, raised strong objection and submitted that it is not a case for stay at present, and further he submitted that and stay order may be passed or stay can be heard after the appearance of the respondent number 2. To stop. However, considering all the aspects of the case, submission made by the learned counsel for both sides, led the further proceeding in GR case number so and so, pending before additional CGM Karimganj be stayed till next date of listing. Also call for the scanned copy of the LCR and then the till returnable date, only till returnable date, list after 4 weeks. Returnable date in a sense, if the if LCR comes and the other side appears, matter may be disposed of finally, because yes, definitely.
Item 6.
Hmm.
Thereafter, between the particular after signing of the FIR on the very next day, because the agreement cannot constitute another arbitration clause was not, an arbitration in the meanwhile, my lord, what each complainant big matter, we executed a kind of share transfer certificate. I came to know about that, and I initiated the proceeding to the NCLT at Calcutta. And there was a bit of option three, my lord. There is a report from the one of forensic laboratory which says my signatures were forged. That is also that page 15. This would have been written under the outlook we have seen that my signature is forged under on page 52 of the document can be seen. Basically, in the case of my non-coding system of certain transactions, this is scheme measurement of the which has been converted into scheme. That is why I'm looking at the these are state of the matter, it was given by the stated because I
Your signature has been forged and which was used in where? Shared transparent agreement. Where is the FIR? The topic information is an email. Huh? It's a long FIR. Cheating, fraud committed by if I have misappropriated money of some people, my lord, and they say that I am now shifting the liability of them. It is a matter of again a dispute as to whether I have misappropriated or not. Who knows, my lord? Because you will be confined to the agreement which you have with us, my lord. So, but now you are demanding money.
Now
As per the
they-
allegation?
Yes, they say I have paid some money. I'm sure
They have come out of real estate.
Yes, please. Page number 40. Oh, these pages are not here, no? Oh, acha, acha. Obviously. Forty-one A2. Yes, from 41A to 41A, B, C, D, etc. and then J. But there is nothing. No, here also we do not find anything. In fact, no, but this is the FIR. You have furnished here the copy. No, no, 18 is the FIR. Sorry, and this is the charge sheet. The charge sheet there is obviously nothing is there. In fact, 41J. IJ. Ah. Where is the 18 above? No, I'm also not finding just gist of the case and how was the investigation. Nothing is there. Huh? This is the charge sheet. Eleven. 11. 12. These are particulars on 13. Witness. List of documents. Brief facts. Sorry? In paragraph 17, 18, brief facts, facts disclosing investigations, it's not here. Why it is not? This is the FIR. This is the charge sheet. Sorry? Call for the LCR, otherwise it will be very difficult on our part because nothing is there. Neither the brief of the facts, nothing in the in regards to investigation. It's simply it has to come from where? Tejpur. It's the duty of the investigating officer to brief the. Let us verify, otherwise it will not be possible. How can it be? Obviously, FIR details was given, but thereafter it's nothing is here. Issue notice. Yes, type copy. We are also being furnished with the type copy here. Everything is blank there. Neither the briefcase of the brief and nothing is there. Is there anything? No. Issue notice. Just issue notice, Koro, and call for the. What is the stage of the case? Cognizance has already been taken. Yes. No. We don't have anything here before us. Before us, it is not here. What is this charge sheet? What is the allegation? What is the investigation? Yes, yes, you have seen. Totally. So you are protection in a sense. You are on bail, I think. Oh. Oh.
I am staying in Gujarat. However, I have to come out there and face that. Similar with the case, which is a civil nature of murder and which is murder.
If it is an, if such kind of order is, then ultimately it will be. Because they are in police bail also. Police bail also. No, you are in police bail. If you appear also, it will not.
Why should I appear? All is my lord, that my lord, issuance of summons is not to be taken in a matter of general manner. It has to be very cautious. In this type of a case, the entire matter dispute is civil in nature. Cases are pending here before police order for high court. Cases are pending here in Calcutta. I have given everything, my lord. Now, if the police officer he does not fill up the charge sheet, my lord, then I have to claim for that. Because I have given the handwriting in the original charge sheet, I have given, my lord. Thereafter, in this basis. Now, if the police officer does not fill that, my lord, and thereafter on that basis, this question ought to have been raised by the government trial court before the matter. Police officer saying that how could you have filed a charge sheet in that manner?
Hard, Mr.
I have given a certified copy of everything, my lord.
So he is given this certified copy also.
I have given a certified copy, my lord.
Heard Mr. G. Chaudhary, the learned counsel for the petition. Also heard Mr. R. J. Burwa, the learned additional PP, appearing on behalf of state respondent. And this is a petition under section 528 of the BNSS 2024-23 for setting aside and quashing of the FIR and the charge sheet and the entire criminal proceeding initiated against the petitioner in connection with Misamari PS case number 74 of 2022 under section 120B, 420, 406, 418, 403, 379 acts. Issue notice for review. Also call for the scanned copy of the LCA. And no formal notice is required to ensure. Next, in the interim, Mr. Chaudhary submitted in this regard that this is completely a case of civil in nature, and with some false allegations have been brought against the present petitioner when he demanded the due, when he demanded the money due. It was an agreement, no? Due to him as per the agreement with the informant. And he further submitted that the present informant also obtained some share transfer agreement by forging the signature of the present petitioner, which is reflected in the FSL report that has been annexed along with the petition. Accordingly, it is submitted by Mr. Chaudhary that till the disposal of the present petition, the petitioner may be protected and the proceeding against the present petitioner may be stayed accordingly. Next, Mr. Borwa, the learned additional PP submitted in this regard that the present petition has been filed for quashing of the FIR and the charge sheet as well as the charge sheet and proceeding also. Charge sheet and entire proceeding, but the charge sheet which has been furnished along with the petition is an incomplete certificate charge sheet, and there is no mention about any investigation or brief of the case. Accordingly, Mr. Borwa submitted that that the scanned copy of the LCR may be called for before passing any order on stay. Next paragraph, hearing this submission made by the Honorable Counsel for both sides, considering the entire facts and circumstances of this case, let the further proceeding against the present petitioner pending, which is pending before? Pending before the Court of Learned SDGM Case Unit 4, which is registered as PRC case number 445 of 2024, corresponding to GR case number 1826 of 2023, be stayed till next date of listing. List after 4 days. No, 4 is not. 3 more game. September 7. Probability before 1 is not there. Maybe at 2. May not be also. Give on
Item 8.
Huh? No. Let us forget about FIR. He did not appear. But his case was pending against him. Maybe he is in Nagaland, but obviously it will appear, the petition cannot be given. Where is your order sheet, sir? You have furnished the order sheets? 36. 36 is the order sheet. In online, actually, what is the business is recorded, in fact, but otherwise you have not furnished any. So now see on the, as per your report only, on the last occasion of the 19/10/2024, the PNA had to be issued, in fact. Considering your absence, PNA had to be issued. And it was fixed for examination of you also, executing officer also. Obviously, he was not available. He could not be found out in his address locality. Oh, that is up to you. He may be a laborer. We are not denying it. Oh, Appear? No. Hard Mr. Archidas, the counsel for the Hmm. It is passed in different context, in fact. Yes. What embargo? Anyway, we are past Hard Mr. Archidas, the counsel for the petitioner, and also heard Mr. R.G. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application filed under Section 528 of BNSS, bringing for washing of the NBW order passed on 12/7/2017 and PNA order dated 19/10/2024, which was passed by the learned additional district judge FTC Nagaon, and also prayed for enlarging the accused petitioner on bail under Section 482 of BNSS, which was registered as SCT2 17 of 2017 under Section 420 and 376 IPC, corresponding to Roha PS case number 300 of 2016 under Section 420, 376 by 511 IPC. It is submitted by Mr. Das, the counsel for the petitioner, that the present accused petitioner was not aware about the pendency of this case, as he was working in Nagaland to earn his livelihood. He never received any summons or summons from the court to appear, and subsequently only he came to know about the issuance of the NBW against him. However, he is ready and willing to appear before the learned trial court below and to contest the case if he is given one more chance to appear before the learned trial court below, and if he is given any interim protection in that regard till his appearance. So he further submitted that the next case is fixed on 22/11/2024. Until that, he may be protected. First. So you have not annexed the order sheets, no? You have only annexed 36, page number 36 is of 12/7/2017, wherein the order of issuance of NBW was there. And there again on 19/10/2024, that is 18, 19, 20, 21, 22, 20, 24. After 7 years, two orders we have annexed. Full stop. Next part, in this context, Mr. Purva, the learned additional PP, submitted that it is not a case. No, he may be this petitioner may be directed to appear before the learned trial court below, but it is not at all a fit case to grant any interim relief to the accused petitioner, as it seems that he is absconding and avoiding the police arrest. Uh, Police arrest full stop. The learned trial court below had to issue PNA against him after exhausting all procedure and issuing and no no after exhausting all the procedures to up to secure his attendance. Next para. Hearing the submission made by learned counsel for both sides, the case record has been perused, and it is seen that only two orders, online orders, have been annexed by the learned by the petitioner, that is dated 12/7/2017, wherein the order of NBW was passed, order of issuance of NBW was passed, and 19/10/2024, whereby the order was passed for recording a statement of EO, and summons were accordingly issued after receipt of the PNA report. From two orders annexed by the petitioner, it seems that the case is pending since 2017 for appearance of the present accused petitioner, and in spite of issuance of NBWA on many occasions, the accused petitioner never appeared before the learned trial court below, for which the learned court had to issue the PNA against the present petitioner, fixing the date for examination of executing officer on 22/11/2024. Considering the entire facts and circumstances of this case, I do not find it proper to pass any order on interim protection. However, the accused petitioner is hereby directed to appear before the learned trial court below with an appropriate application for bail, which shall be considered in accordance with law. With above observation, it stands disposed of. You appear before the learned trial court below. Huh? No, protection is not there. Now see, this case is pending since 2017, now 2024. Since 2016-17 onwards, the court is issuing process trying to procure the attendance of the accused petitioner, but he is avoiding. He is simply walking in Nagaland. That cannot be accepted. Yes. Okay, disposed of. ইমান একেলগে চব দিছে কেনেকৈ দি থাকিলে থাকি যাব আৰু উপায়টো নাই চব দিছে ক্ৰিমিনেল পিটিশ্যনতে পচিবল নহয় নাই য়েছ 9 য়েছ হা
Subsequently, the case was transferred to Sunai police station. After the case was transferred to Sunai police station,
unauthorized, these sections were changed and every page was registered in that page, page 21. It is section 420 to the lines below. 324, 325, 406, 506 and 34. I did not complain about this. This is not my case under section 355. Ultimately, the police, without investigating the case which was registered originally, it submitted the penalty. I am telling you this penalty. Two, police said that no evidence was forthcoming and that it is the case to be lesser effort. So, at this stage, my prayer would be only to issue notice. Police cannot change during investigation, cannot change this section. And sections, even if changed, that must be with the permission of the court. Number two, we should conform to the allegations made in the attack. We did not make any such allegation.
Obviously. How it has been changed? Notice has already gone. Okay.
Now, madam, one that FR is submitted, madam, notice is issued to the informant. Informant, madam, he can appear before the trial court. He can find another case. They pick the FR. Then, madam, trial court, madam, may take cognizance of the
Obviously.
madam. The trial court may direct to, madam, to do further investigation. In this case, madam, he has not done anything, madam.
I have done this. I have made
When
it.
the trial court has rejected, madam,
No,
then he may come before
it is another point that I should aside.
No, satisfaction is otherwise, but the question is, have you appeared before the learned trial court below after receiving the object notice? These are not here. Trial court order, you have annexed the trial court order?
On receipt of the same final report in court of paragraph 4 month, at page 6,
Paragraph 4.
paragraph 4.
Hmm.
On receipt of the same final report, the honorable court of the implementation shall issue a notification asking the present petitioner to appear before him on 17/8/2020 to court to file his objection in in response to which the present petitioner has filed an objection dated 30/10/2020 which is pending adjudication.
Oh, that is still pending for adjudication then.
But there will be no result because that is the case.
how can he issue, madam,
How can you say?
Because of the section, this section.
No, how can you say your objection will not be entertained?
Now further investigation will be in respect of the case registered.
No, whatever. How can you say that the objection is not been entertained or it was still pending for adjudication?
Full result will be coming because this is in respect of the case which was subsequently registered. Changing the sections of law. I have already.
No, you will get the scope to place the entire case that it was earlier registered. Then it,
Further investigation.
his submission is that mother you must have director, so that is normal must have director to the trial court to mother reject this what
No,
this
I,
cannot be
it is not my.
this cannot be
I-
if he has filed objection must have trial court must have
Only to adjudicate my FIR, investigate my FIR. That is my origin as originally registered. They changed it. They changed the sections of law. FIR.
no, whatever, you can place all these things before the learned trial court below in your objection. That this is the things. Actually, my original FIR was there. Huh?
In this case, where is the scope for trial court to order reinvestigation in the case which has been registered and changing the sections of law. That's why I am saying.
No. Yes. You can make a complaint also. The police accountability before. No order is there. You agree by under against which order? Eh, No order. Then
Only because of
you have come for the revision, the criminal petition for.
change of
That is not here. We cannot get the relief. In fact, you want to withdraw.
We will be liberty to file the time.
Okay, then. Better to withdraw. You file the petition after this order of the court below. Bring all these things, place all these things before the learned trial court below. What was the original FI? Why it has been changed? How it can be changed? Then prayer for investigation you may made before the learned trial court below. That prayer may be allowed also because it's a very serious case. I have seen the entire matter was actually for tampering of the signature and all these things. But the FIR is registered subsequently under section 324, 325. Entire thing has been changed, which they have seen. It's a very serious nature of case. You just withdraw this one, try to get before the learned trial court below. Yes. With a liberty to file? Okay. With a liberty to file. Hard করে দিব you are Mr. NH Mazhar ভূঞা আৰু স্কোপ হাৰ্ড কৰি দিব this is an application কৰি দিব আৰু তাৰপিছত instructions of defendant he wants to withdraw with a liberty to file a fresh prayer allowed it's disposed of accordingly on withdrawal. Okay, you take your liberty.
Adjournment.
Actually, what it weapon I have most probably from 2 division bench will be there with Justice Surana in fact, and then by 3 we have to rush for the Uttar Guwahati, in fact not Guwahati. And that's why there are lots of matters maybe left over today. I don't know. Lots of matters are there. Anyway, you are on item number 10. Yes. Joint. Child marriage. Sorry. Husband and wife. Now we don't know husband and but the POXO is there. Husband and wife. Child marriage. If child marriage, then the obviously at the time of incident and all, the number 2 is was a minor. Whatever, yes, Burwa, what to do? Ah. Where the order was passed in same circumstances? In which court? Better to file this one, I think. My view may be different. My view may be different. I'm just saying it. In some high courts, there are some orders, but my personal, I'm saying that my personal view that I have already rejected 2-3 more cases matter this. No, just I'm saying you can file it before the appropriate bench only. That bench I cannot say. How can I say that bench? No, just see I have seen. You may not be fruitful result may not be there. I'm going to issue notice to whom? It is a joint petition. No, I'm not. No. State is the only respondent, na? Okay, we issue notice. We'll call for the case record. What is the stage of the case at present? Framing of charge. Charge has already been framed. No. Where it is pending? Where it is pending before which court? No. In which before session judge or special judge? It's a special judge, Mankachar, South Salmara.
my lord, read it 9, 10, 11 of time very take.
Hmm.
There, my lord, read it, my lord, 17 my lord, take.
Hmm.
And English, yes, my lord, informative, software on Muhammad Mian. So they are the my lord, one petition, they are the husband and wife. That is one of the total of the my lord, informative. Informative is the one illustrated. That is why I am not the right to pose that. Notice maybe no shit. It is there. No, it is a while.
You have not made party. Informant is not made party here. Now, victim is what kind of victim? He is, she was a minor at the time of her marriage. That's why Section 6 will also come. Child marriage will also come. How can you push? Okay. We issue notice. Okay, you can see.
This is a common problem of the government of Assam. It is there. About the lordship to prevent the scientists in Assam. That common affair has been done. This is not Assam. That the form of GPC. Those this area and this is your I would like to include that final decision of this. That's why I have noticed that one of the first one of this the other is not police as part of the officer of this police. I have personally but the case of that and I have to inform that the case of the damage to the yes, I have collected the data sir as I have learned that the medical is pregnant as per my information. The drug was very pregnant. She might be very Father, I am also informed that the ministry is the lady kingdom and the group and the ministry was welcome to the local level. There is a difference to start. The producers of the matter and necessary process. What the style is we take an aspect. Today, later, on law is they are not able to and they are maybe they have as per the style they have to be and the procedural result yes, they have to be the similar circumstances is another code as a process proceeding. I would like to just write down last. In brief, the case of the petition is that on 16th February 2021, Anushka lost her affair releasing intermediate and her minor with them tells the petitioner under this lines. It is stated that for the initially section 6 of the Constitution was also registered under the section, but subsequently after this again the petitioner it was accordingly for the larger and according to the larger same standards ITC and the again predisposition of what to understand ITC. But the proving of charges of
Now, this order was passed in the context with the circumstances a bit different. It was a different circumstances. So, by issuing notice here, stay, prayer for stay. Stay can be given. Stay is there. Okay, stay to DD. Now, stay is there. What is the stage of the case at present? No, it's okay. Charge sheeted case, but the. Mm. 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 Yes. Here in this case, both the victim and the petitioner, they have appeared jointly filed the petition. Obviously, it is a case at the time of marriage. She was minor, undoubtedly. I don't have any objection. He submitted one thing, but this is the circumstances that could be different. This was misunderstanding and all that. So, but here it is cannot be a case of misunderstanding because they stayed together. She got pregnant. Now still they are staying as a husband and wife. It cannot be a case of misunderstanding and all. They're still there. So this is pro. But now the question is that as the petition is filed jointly by the victim and me, that is the only reason I'm going to stay. Otherwise, there cannot be any. Let the till the next date of listing, it may be listed. We calling for the case diary, case record. Matter may be disposed of that much. Yes. Objection to record video. Hard Mr. Swain's video. Ajad Ahmed, the counsel for the petitioner, and also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. And this is an application on section Swain's video. Issue notice video. No formal notice is required. Call for the scanned copy of the LCR video. Yes. Yes, informant has to be party. Further, full stop. However, it is seen from the cause list of the the cause title. It is seen that the informant of the case is not made party in this case, though the petition is jointly filed by the accused and the victim of this case. Accordingly, Mr. Ahmed is also hereby directed to amend the cause title and imprint the informant as a state respondent, party respondent here. Mr. Ahmed further submitted that as both the victim and the informant has appeared before this court, the further proceeding may be stayed till disposal of the present criminal petition. And if he further submitted, even if the petition is case is allowed to continue, it will be nothing but the abuse of process of the court. Next, Mr. Borwa, the learned additional PP raised objection and submitted in this regard that from the FIR as well as from the and from the charge sheet also it is seen that at the relevant time of incident the victim was a minor and the accused got married. Accused married the victim and also had sexual intercourse with her, for which She got pregnant of 5 months at the time of the filing of the FIR, at the filing of the charge. However, it is a fact that the both informant and the victim have jointly, no, sorry, informant, no, the accused and the victim jointly filed the criminal petition. Considering this aspect of the case, let the further proceeding in uh, in connection with case number so and so be stayed till next date of listing. In the meantime, Mr. Ahmed will also file the amended cost addendum, including the informant as a party respondent. You implement the informant as a party respondent if matter is stayed. It will be listed after 4 weeks. The LCA has also already been called.
Item 11,
This will be last item. Yes.
The gist of this case is a contractual dispute between the respondent number one and the petitioners. Complete case, which I seek the copying of it. And there's an order of discharge. So, whereby my discharge application is dismissed. That also is. Which is the gist is in 2013, the respondent and the petitioners entered into an agreement. The agreement says that from February 2016 to February 2021, there will be a profit sharing relationship between the respondent number one and the petitioner. I have a wine shop. The petitioners they run a wine shop. Petitioner number one is the excise license. Now, admittedly, the security deposit, which was 13 lakhs, was not. This is an admitted fact. In the initial deposition itself, the respondent number one and the power of attorney holder have said that we have paid 5 lakhs of security deposit out of 13 lakhs. This is also there in the complaint. They say, your leadership, that we bought 67 lakh worth of stocks of liquor bottles for the wine shop. The document, your leadership, which they annexed the complaint, page 80, it's a fabricator document. Your leadership will only see page 80 for a moment. This is the document, which is the clinching document that they're using in their complaint, it's page 80 here. Only one document your leadership can kindly see. This, they are saying, shows that we have purchased stock for a liquor shop. There's not a single signature, nothing in it. Stock register is maintained in the excise office, then that is not brought before the honorable court. They say in your leadership that we have paid 1,80,000 as rent for the liquor shop. And they have brought before the magistrate unsigned documents in leadership. Leadership will kindly see on page 64, 64, 65, 66 leadership. These are unsigned documents. Other than this, your leadership, what they have annexed, leadership will kindly see from page 58 to page 63. These are documents which show that petitioner number one has paid the shop rent to the landlord of the shop from page 58 to page 63.
Petitioner number. Petitioner.
Yes, petitioner, not her. Petitioner number one is paying the shop rent from page 58 to 63. Your leadership will see these are analogous documents. They say that Manoj Kumar Mora, petitioner number one before your leadership, is paying shop rent of 45,000 to Vipul Kumar Sundari, who is the landlord of the shop. Now, your leadership, in the initial deposition for the London magistrate, the respondent number one says that we have also filed a civil suit. Your leadership, that civil suit got withdrawn in March 2017, and they have not filed a fresh suit after taking liberty. And that suit, your leadership, was for specific performance of this agreement, which is the fulcrum of this entire complaint case. Now, your leadership, before the London magistrate as well, your leadership, we brought any kind of this to the London magistrate. But there is ultimately, in the complaint itself, your leadership, there is a paragraph where there is an illegal motive which has been pleaded by the complainant. That this was the motive behind the agreement. I'll just show one paragraph from the complaint, your leadership. Leadership, can you have the complaint, which is at 32 years.
30?
32. Complaint begins. Leadership, can you have directly paragraph 12 at page 40. This paragraph, leadership, is because the agreement. This is not based on a clause of the agreement. This is the understanding of the complainant that she's speaking. Only one line that it is stated. Let me read it. He stated that the accused, who has dominion over the wine shop, by virtue of INFL license, it is transferred, the leadership is transferred to the name of the complainant firm by the excise department. The leadership, these are settled under Rule 300 of our excise rules. INFL licenses are not transferable. And this is not there in the agreement also. So, leadership, the mistake of the petitioners herein is that I did not fall prey to the complainant's demand that he transfer the license. I have done something legal, and therefore I am being subjected to these proceedings. There were 2 FIRs also leadership which were registered by the complainant against both the petitioners. One against petitioner 1 and one against petitioner 2. In both, I have been acquitted. And I have annexed those orders as well. That is annexure 2 at page 90 and annexure 3 at page 92. The first one, where leadership, the order is not immediately applied to a certified copy. I have read that leadership was placed. At page 91, your leadership will find the operative portion of the order, whereby petitioner number 1 is acquitted. And at 92, petitioner number 2 is acquitted. In both of these, the allegation was that I was illegally entering the wine shop. My wine shop. Respondent number 1 is saying that I was illegally entering and I was trespassing and I was creating havoc. I was mistreating the employees in the wine shop. In both of these, I have been acquitted. The leadership, my pleaded case is that this is an absolutely vindictive complaint case, which has been filed with the sole motive of taking vengeance on the petitioner. And leadership is well aware, recently there's a judgment of the Honorable Supreme Court where it has been very categorically held your leadership that I will place the judgment for your leadership's Para 28 and rely on it. I will not read the entire paragraph. The Honorable Supreme Court has held where there is a 482 petition where it is pleaded that the FIR or the complaint has been filed for taking vengeance or out of vindictive motive. The Honorable Court, the High Court, should read between the lines of the complaint or the FIR and the attending circumstances surrounding the filing of the FIR, surrounding the filing of the complaint, that we also be looked into by the Honorable Court. Therefore, we in my humble submission to complaint.
You are insisting on para?
The para 28, page 50. Now, your leadership on 26 charges will be framed against me. My petitioner number 1 in leadership is probably on a degree transfer. So, on all of these grounds, what I have argued is on this very basis, I humbly pray to see this very state of timing. Notice may be issued. So, only 2-year election is a state.
It's a complex. You are the formal party here? Okay, I'll pass the order. It will take some time. Actually, 1:15 we have a meeting, in fact. So, the rest of the matters I don't know. At 2, if it is possible, 2 to 3, I'll take up the matters. Otherwise, I have a division bench also. I don't know what will happen. So, it's okay. You had this any 1-5. 1-5. What's the admission, na? Stage.
Subsequent developments. Another, we are coming with a proportion of the second FIR.
Acha.
Now, a third FIR has also been and searching has been submitted. So, we get a request of work for give us a copy of the search. We are expecting that copy. So, we then need to file a additional invitation because from the original case, 2 FIRs have subsequently developed. So, we are waiting for portion of the second
FIR, yes.
Now, we may have to find another case for portion of the third FIR because everything is calculated to the original case. Therefore, I am waiting for only this paper for a little bit longer time. Because we may need to get all these documents also. And I also read that process here, we just observe that the lawyer will give us the second copy of the FIR 6.
Standing Council, CBI is also present here. Oh, hello is there. Yes, they are seeking some time. In fact, as per the third FIR is also there. They were earlier seeking for washing of the second FIR out of same thing, and now the third FIR is also there. So they want to file some additional affidavit in the form of by collecting all this. Is there? Do you have any objection? He has the copy.
There's a direct reference to our FIR. Just one. We are seeking washing of the FIR dated 24/7/2023, and that is the first line of the third FIR. If I am allowed to read it, it is submitted that a regular case was registered in CBI on 27 July 2023 by case number RC so against Santosh Kumar Ji, and then the Vikas Shah, etc. So the beginning of the third FIR started from this regular case, where we are seeking interference of this honorable court. So there is a direct connect of the third case with the second case. There is already a first case where searching has been filed.
Yes. Now you are seeking washing for the second FIR.
Second, and now a third case has been filed, and there also searching has been made, and we made a request day before yesterday on 13th. Give us a copy of the search. It was not registered and it was received by them, but I don't know the court below, but no copy was given to us. So my observation here before this honorable, they will be make an observation that the lower court will submit us the FIR copy as well as the search.
No, FIR copy and the charge money. Even you prayed for the copies.
Yes, we have.
Mr. Hello, you don't have any information regarding the third FIR?
This is why the first line is started with the second FIR. Possible case. That is why we want to check whether the facts are same or different and how the investigation progresses.
First line, there is some. It is submitted that the regular case registered of CBI on so and so by so and so is there. Is still mentioning about it. And the rest of the part I don't know. Maybe the third FIR it may be considered as a third FIR or may not be. I don't know. Circumstances, facts may be different. Let them check. And but February they're taking time for February. In fact, February will be long, so long.
Will they be around second week of January? So we may have to file another case after getting all this.
No, they may bring all these things into record by in the form of edition. That is different thing, but obviously there has to be another case. Let it be on the prior Bihu then, first week of January. Then first week. Till law minister is coming, we have to rush him. That's why. Yes, bill direction I have noted down here in the I mean the cause this itself will pass the order. It will more pass to be total wages. Let us see if it is stay, stay. If it is not stay, not stay. Okay. Thank you. Yes. First week of January. She is suggesting 9th. 9th of January will do. Prior Bihu.
He will have a birthday, we will celebrate.
Okay, then 7, 8. If 9 is okay, we'll be fixing on 7.